SJC-11758, Pagona Christakis v. Jeanne Credit Union.
Morning, Mr. Baker. You may proceed.
Thank you, Mr. Chief Justice and Associate Justices. May it please the Court. My name is David Baker. I'm here on behalf of Appellant Pagona Christakis to ask that this Court reverse or vacate the order and judgment of the Land Court in this case, which granted summary judgment in favor of the appellees. Summary judgment was appropriate because the facts really are, there's no genuine dispute about any material facts here. Ms. Christakis owns certain property in Billerica. The property, so far as I recall, is not her homestead. It's commercial property. I believe it's undeveloped. She is seeking to, ultimately she's seeking to develop the property. She acquired the property in, I believe, 2006 or 2007. In 2008 and 2009, 3 creditors obtained executions and recorded them at the Registry of Deeds. There are 3 lots at issue. One of them is recorded land, and I believe the other 2 are registered land. In an event that wasn't, the distinction wasn't material to the issues here.
Could I ask you a question?
Certainly.
No, actually, continue. I'll get there. Sorry. Go ahead.
Okay. Thank you, Your Honor. In 2010, I believe it was, yes, 2010, Ms. Christakis commenced a Chapter 13 bankruptcy case here in Boston with the hope of reorganizing her debts and her financial situation. She was represented by very competent, very experienced bankruptcy counsel in that case, other than myself. The Chapter 13 reorganization was not successful, so the case was converted to one under Chapter 7 in 2011. Ultimately, she received a discharge under Chapter 7 of the Bankruptcy Code in 2011. The issue here is, I think, much more straightforward than the appellees seem to believe. The question presented here is, when the Chapter 7 discharge issued, as a matter of federal bankruptcy law, the judgments of those 3, underlying those 3 executions, became void as a matter of federal bankruptcy law. No one disputes, certainly not me, the fact that the lien of the executions passed through the bankruptcy case unaffected. Now, the Land Court and the appellees seem to think that if the liens were avoidable, they should have been avoided in the bankruptcy case. There are certain circumstances under which the bankruptcy court has jurisdiction to avoid liens. For example, if the underlying debt is not a valid debt, or if the lien impairs an exemption to which the debtor is entitled under the Bankruptcy Code. As mentioned previously, this property is not her homestead. It's commercial property, so there really was no Bankruptcy Code exemption that she could
Mr. Baker,
obtain.
were you referring to this 11 U.S.C. Section 524, which provides that a discharge in a case voids any judgment at any time obtained to the extent that such judgment is a determination of the personal liability of the debtor with respect to any debt discharged? So isn't the question here whether, even though there is no in personam liability, whether there's in rem liability, and why that section would have any relevance to in rem actions?
Well, the answer to that is that, as I say, nobody disputes that the lien passed through bankruptcy unaffected. But the question then is, now what? Okay, as a matter of state law, and this is, I want to emphasize this because this is something that gets confused, I think. We're saying that under state law, when a judgment is void.
But why is that judgment void, since it doesn't have anything to do with in rem? It's only void to the extent that the judgment is a determination of personal liability of the debtor.
Right.
But this is not a determination of the personal liability of the debtor, is it?
Sorry? I didn't quite follow.
Here, is it only the personal liability of the debtor when they have pre-existing liens?
It's only the property that is the subject of the suit.
Yes. Well, no. Are you referring to the land court suit? Or?
Well, the recovery sought is against the property, not against the individual.
No, these were pre-bankruptcy ordinary collection actions, I think perhaps in the district court, based on credit card debts, I believe. So the original action was an in personam.
Right, but that's not the case anymore, right?
No, this is still the case, because the execution refers to the judgment in the in personam judgment that the district court, or whichever, issued.
I take it what you're saying is that to the extent that the lien is based upon a judgment, and that judgment has been essentially rendered void by the bankruptcy court, the lien is no good.
Right. I will be a little more generous about it. It remains good until the court says otherwise. Okay, and that was what we were asking the land court to do, to say that because the underlying judgment is void, the liens are also void.
And why should the liens be void? I mean, if Ms. Christakis had sold those commercial properties, they would be available for distribution pursuant to the bankruptcy. She chose to not do so, so she kept those equity in the property. Why should she be better off because she chose not to sell commercial property to pay her debts than if she kept the commercial property?
Because, again, the underlying judgment is void. I mean, this is really a novel issue, I think. Case law that I've seen on the issue of void judgments is consistent, that if the judgment is void, it must be vacated under Rule 60. Pardon?
So let me, I think what Justice Spina said is correct. So you're saying the underlying judgment on, this is simply security for the underlying judgment, right?
Yes.
And the underlying judgment is the in personam judgment against her for the credit card debt.
Right.
And that part has been rendered void by the Chapter 7 discharge.
Right.
So the tail can't wag the dog.
Okay.
Right? I mean, that's what you're saying, that you can't, that the lien is part of a judgment, and the judgment is a personal judgment, and therefore the lien has to go.
Yes. That's a very good summary of it.
Has this ever come up before?
I don't think so. As I said,
In 50 states, in 200 years, or however long the bankruptcy code has been around, it's never come up.
I don't know about other states. I've obviously focused my research on Massachusetts law, and I don't think it's come up in Massachusetts. There are lots of cases about void judgments, and but they tend to focus on on issues of whether the trial court has subject matter jurisdiction or whether the summons and complaint were properly served, due process type arguments.
Could you, I don't know, could you file a petition or a motion under Rule 60 to vacate the judgment? Is that possible?
I would think so.
But that's not what you asked the land court to do.
No. We asked the land court to clear the title, clear the clouds on the title. My recollection is that the three judgments were from different courts, different district courts, so it would have been an inefficient and expensive process to go to each court and ask them to void it under Rule 60.
Mr. Baker, would the relief that you're seeking in this case, would that conflict with the federal law? I mean, we do have this Johnson versus, I think it's Home State Bank. What you're asking for would be totally different from what the federal law requires once somebody goes through bankruptcy. So how could we have a result that conflicts with federal law.
I submit that it doesn't conflict. The Johnson versus Home State Bank recited the rule that was first established in a case called Long versus Bullard in 1886 from the U.S. Supreme Court. Long versus Bullard and Johnson versus Home State Bank pertain to mortgages. I am not saying that a mortgage, which is a consensual lien, or for that matter a UCC lien, which is also consensual, would be in any way affected by the relief I'm asking for here.
So why is a judicial lien different from a consensual lien? What's the distinction there? What requires us to treat them differently?
Because they originated in a different manner.
Well, a lien is a lien is a lien.
Yes, but the law makes a distinction between how the lien was created. A mortgage and a UCC lien are consensual liens. It arises by contract, by an agreement. But a judicial lien arises because a plaintiff has gone to court, proven his case, gotten a judgment, and a judge has issued a judgment following which the clerk issues an execution.
But doesn't a bankruptcy court have the authority to essentially void a contract?
Well, a contract is a debt that is dischargeable. Yes.
Yeah, and so if the bankruptcy court can wipe out something that's voluntarily entered into, why I'm having a little bit of trouble following the distinction you're making.
Okay, well, I sort of hate to go back to this, but again, the point is that liens pass through bankruptcy unaffected. And nobody disputes that. I certainly don't. If the contract involved a lien, for example, with a mortgage, we have a note, a promissory note, and the mortgage itself. A bankruptcy discharges the mortgagor's obligation under the note, but it does not discharge the remedy of foreclosure under the mortgage.
Okay, so using that analogy, if the underlying debt of the mortgage is wiped out, but the mortgage is still good, why isn't it also true that where there is a judicial lien and the underlying judicial process has essentially been negated, the judicial lien is still good?
Until the court says otherwise. And that's what we're asking the court.
So why should we say otherwise?
You should say otherwise because the judgment is void.
Well, but so is in the case of a mortgage, so is the underlying note. It's no longer valid.
But a mortgage is not based on a judgment.
And it's a matter of federal bankruptcy law that the mortgage remains. Federal bankruptcy law says fine. So you have this contractual agreement. It wasn't discharged as a matter of federal law, and therefore a state court will enforce it. And you're saying you have a lien that's not discharged as a matter of federal law, but because it's attached to a judgment that is void, it becomes void itself as a matter of state law.
I would say it becomes voidable.
Avoidable.
Until the court says otherwise. But yes, that's it.
But you still haven't explained. I assume that we have a choice here. I assume that we can declare it voidable or not declare it voidable.
Yes.
Okay, and I guess the question is, why should we choose to declare it void where, at least under federal law, it is void only as to personal liability and not as to in rem? Because
I'm trying to emphasize the distinction between the judgment itself and the lien, which is based on that judgment. If the judgment is void, I just don't see how an execution lien can be.
But under federal law, it's not void as to all purposes. It's void only as to personal liability.
The judgment.
Right.
Okay. I agree that the lien passes through bankruptcy unaffected. You know, the discharge in bankruptcy has nothing to do with the validity of the lien. That's why we repair to the, so to speak, to the state court for the declaration as to the validity of the lien.
But where I'm having trouble is, I understand your argument that the judgment is void and this is attached to the judgment, but why, under your theory, is the lien voidable and not void the way the judgment is?
Well, because perhaps I'm being too conservative about it. I prefer to say that, and giving due respect to the court that issued the judgment and execution in the first place, I should really go back to the court and get, in respect for the court's authority, and get a declaration as to the validity of it.
But you answered Chief Justice Gantz that we had a choice whether to declare it void or not. But I don't understand how that logically fits with your argument.
Because, well, I guess the best answer to that is there's no precedent either way. If there was some precedent that said conclusively one way or the other, then we wouldn't have the question. I think ultimately the point here is that if Ms. Christakis, for example, wants to sell the property, as I think Chief Justice Gantz mentioned before, in the absence of a declaration that the lien is void, a title examiner is going to say, you got to pay off these liens. And again, that is the point here, to clear the liens from the title, get a court order saying that the liens are no longer enforceable.
Well, if you recorded the discharge in bankruptcy in the Registry of Deeds with a cross-reference to the liens, would a title examiner be satisfied with that?
I doubt it. I seriously doubt it, because excuse me, because everybody does focus on this principle that liens pass through bankruptcy unaffected. A title examiner, I am reasonably confident, would say, you got to get me a court order or you got to pay the liens. So that's the point here. We need to clear the title. We need to get the clouds off the title.
All right, thank you.
Thank you, Your Honor.
Time is up.
Good morning, Your Honors. May it please the Court. I'm Sandra Boulay, and I'm representing Jeanne Credit Union. In this matter, the creditors, which credit union plus the other two that were listed as defendants, all made seizures of the property. They took their judgment, they got an execution, and they seized the property by a sheriff's seizure.
Has this come up in any other state that you're aware of, this issue?
Well, the issue in Home State Bank case, the U.S. Supreme Court case that was cited in the amicus brief, cited other cases that were non-consensual liens. So even though that was a mortgage, it was also referencing two other matters that were non-consensual liens. It also has come up in the essence of the Colonial Bank case that was cited in the amicus brief, whereby after the foreclosure of a mortgage, after a bankruptcy, both cases involved bankruptcies, the proceeds that were left over, the surplus proceeds, weren't the debtor in bankruptcy wasn't entitled to the proceeds. They were to be parceled out amongst the junior creditors, which were the junior creditors being the lien holders.
Yeah, but those were liens.
They were liens.
And if the proceeds are sufficient to pay off all the lien holders, where would the excess go in that circumstance? Would it go to the other creditors, the unsecured creditors in bankruptcy? The bankruptcy court case have to be reopened?
If you ran, that would make sense. But I think I apologize for my stumbling here, but I would because the bankruptcy trustee abandons at the end of the discharge, they abandon what's not what they didn't make claim to. So I would say that it would go to in that case, once you've gone down the list of the people that are junior creditors, it would go to the owner of the equity of redemption, which would be the owner of the property.
Now, how is this different if this were a homestead? Would you be able to seize the property if it were a homestead?
In the bankruptcy, and that's why the bankruptcy piece of this is critical. I mean, the state court judge, Judge Long, was applying state law and then deferring to the bankruptcy court to make other findings based on the debtor's rights under bankruptcy or opportunities or the things that they're availed of to get their fresh start. So he didn't go to the extent of and nor do I think that he would have jurisdiction to determine exemptions. The exemptions aren't claimed, then they're not exemptions for that debtor unless they later do something about it by reopening the case. So as to the matter of homestead, Your Honor, there was an earlier case where homestead, under the bankruptcy code at this time, if someone, there's an automatic homestead in Massachusetts, but before that even, if someone claimed that homestead prior to going into bankruptcy, then that could supersede the lien holders. In our case, we didn't have homestead as an issue because homestead wasn't a factor. It was not her primary residence property. In her bankruptcy,
Right,
she cited
but here's my concern. This is a commercial property, and you have a debt arising from a credit card, and if the result is that somebody loses commercial property, that may be an unhappy circumstance for him, but the world carries on. If it's his home, we may feel differently about allowing a credit card company to take a credit card debt, get a judgment, obtain a judicial lien, and then, as a result of that, be able to foreclose on somebody's home, essentially transforming what was an unsecured debt through a judgment where the credit card holder usually defaults into a lien that can result in foreclosure. Are we opening the door to that if you prevail here?
Well, in this, I don't think this, whether we prevail here or not, I don't think it changes the character of what occurs when there's a homestead or not, because in a bankruptcy matter, people select a scheme of how they want. In Massachusetts, they have a choice. Do they pick the federal scheme of exemptions? Do they pick the state exemptions? The federal exemptions are less generous as to homestead. The state exemptions are more generous. So people make selections based on what they have for assets that they want to exempt. So the same issue would arise no matter what they might have claimed as an exemption in bankruptcy. So you just basically would go down the list. If they were in the bankruptcy court and the bankruptcy court was reviewing it, the bankruptcy judge would be looking at the motion to avoid a lien. They would look at what is the value of the asset, what is the claimed exemption, and whether or not that judicial lien is impairing that exemption. So in this case, I think that's why my brother says it would be futile for them to go back to bankruptcy court, because under the scheme of exemptions, they didn't make that claim of exemption that would have exempted this piece of property that was liened upon by my client.
But if we had different facts and this really were her primary residence, I take it from what you said that under Judge Long's ruling, it would go back to bankruptcy court, and the bankruptcy, and assuming that there had been a homestead exemption claimed, the credit card holders would not be able to recover on their lien, correct?
Unless their property way exceeded the homestead exemption, amount, which, I mean, if the property was a $2 million property and there was no mortgage on it or...
Oh, I see, yeah.
And if that's the case, could you foreclose?
We could foreclose on that lien, subject to the homestead.
Which means you would be able to foreclose, they would get the homestead amount, and you'd get the balance.
That is correct.
But in that case, does it become a personal liability or an in rem liability? Because you're essentially liquidating the house into cash, giving the homestead amount to the homeowner, and then keeping the balance, but the balance would be the equity that otherwise would belong to the homeowner. So is that then a personal liability or in rem liability?
I would state, Your Honor, that it would be in rem coming out of the sale of property, not going after the homeowner for the difference. are going to them to seek money from a different source. The money is coming out of the real estate, which is the seized asset, which was taken at the time of the seizure. And that's why in the cases that were cited in the briefs originally, the Lewis Beef case, that was a very different fact pattern that my brother cited to favor his position, but really didn't favor his position, because in that case, the attachment, that there was an attachment there was two different cases, an attachment, then a judgment in the district court with no execution issuing, then a second case where there was a judgment issued, no execution obtained, and then the person filed a bankruptcy, and then after the filing of the bankruptcy, they said they went to the court to ask for an issuance of the execution to then make a seizure. So the seizure hadn't been made before the bankruptcy, which is really the difference in our case versus that case. And the other case that was cited by my brother that was a matter of preferences. You know, if the execution occurred a few months before, now 90 days before, but in that time period, 4 months before, it was considered a preference, because the trustee in bankruptcy would have a right to say, to the extent of non-exempted property or property that exceeded exemption values, that property belongs to all creditors to be shared equally and not to one that happened to jump on it and get their lien secured ahead of these other folks in such a brief period of time when the person was actually insolvent.
Could Mr. Baker go to the courts that issued these judgments that have given rise to the liens and bring motions under Rule 60 to have the judgments vacated?
I don't know if he could. He would have to show, because at the time that judgment was issued, his client was not in bankruptcy, so there was no reason why that valid judgment shouldn't stand.
But now the entire basis for the judgment has been undercut.
I think, but the bankruptcy code is very clear that a lien survives bankruptcy.
Well, so he's trying to do something slightly different and come in through the back door and attack the lien by attacking the basis on which the lien was. Well, if this did not involve a bankruptcy case and a judgment had entered and the judgment had been recorded in the Registry of Deeds, and he filed a motion under Rule 60 a year later claiming that the judgment was entered on the basis of fraud on the court, the judgment would be vacated and something would be recorded in the Registry of Deeds to note that the lien was no longer good.
And that would be to the underlying case at bar in that lower court.
Yeah, and so he's trying to do the same thing now by, at least qualitatively the same thing, by saying that there's no basis for the court's judgment to stand on the books as a valid judgment.
I think that I understand that, but I disagree with that could happen. I think that what he could do is file a bankruptcy, a suggestion of bankruptcy in the court, and then on the clerk docket they would record possibly that, and then if someone then later went to seek an execution, that wouldn't issue for someone who hadn't done that. But when the creditor went through and did all the steps promptly, I think that made the difference, because they took the seizure, and it's the seizure and the property. That's that point of taking the property, the transfer of the property from the owner to the judgment creditor occurred at the time of the seizure. So even if that could happen, it would be my contention that would not change the result in the sense that of avoiding the lien.
Well, I mean, to play devil's advocate, though, I mean, if you have forget bankruptcy for a second. If you have a mortgage on and the mortgage is foreclosed upon, and at the time everything seems valid, but later, years later, through some lawsuit, the mortgage, the whole transaction is declared void, the mortgage foreclosure, then it doesn't matter, right? I mean, isn't this sort of the same?
Well, if the mortgage foreclosure is declared void, maybe that's a procedural issue occurred. They could still turn around and re-foreclose.
Well, maybe they could, maybe they couldn't, but it would void that transfer, even though it was valid at the time that it was made. It would void it.
It wouldn't void the lien, though. It wouldn't void, the mortgage wouldn't be void unless there was something in the, again, the mortgage itself isn't void, that's the security interest. The lien and the execution being levied upon, or the attachment, if you have a prejudgment attachment, which the credit union in this case did, that moment of attachment was the time of the seizure of the property, and the fact that the execution was levied upon within 40 days. Under the statute of Massachusetts that addresses that, it gives it the retroactive effect of even the attachment period. So the attachment point is a point of the transfer of the property. The in rem belongs now to the creditor.
But if what is a judicial lien apart from a lien to enforce a judgment?
It's the judicial lien is you take either an approved motion within a process, that attachment document under the seal of the court, or an execution under the seal of the court that is the process that allows that sheriff to make that.
Okay, but going back to Justice Spina's point, if you had a judgment, you obtained a judicial lien based on that judgment, and then for whatever reason that judgment was declared void through a motion to the court, would your lien could not survive because there was no longer a judgment to collect upon, could it?
If it was void for a valid reason, I don't know that you could void it. I don't think it's voidable like that.
So you're saying that if I collect $100,000, if I get a judgment for $100,000 and then obtain a judicial lien upon the defendant's property to collect the $100,000, and then it turns out that I obtained that judgment by fraud, and the court voids that judgment, that I can still foreclose upon your home based on that lien?
No, I would not say that at all.
So what he's saying here is that the bankruptcy has the same effect as the voiding of the judgment, and therefore it has the same consequence on the lien.
But it doesn't void the judgment because it's to the extent the bankruptcy liens pass through bankruptcy unaffected. It said that in the discharge 727 of the Bankruptcy Code. It basically talks about the effective discharge. Even the forms that the bankruptcy court issues to the debtor it refers to the fact that this doesn't avoid all
But
liens.
that's just a matter of federal law, and I think the point is, as a matter of state law, if you've got a void judgment, personal judgment, then things can't attach to it like a lien.
But if you had the void judgment, the judgment was voided as of the time that it entered, not after some declaration that it could be. I don't think it could be voided afterward, even if there was the bankruptcy itself doesn't void the lien. It doesn't have that effect.
Well, it doesn't void the lien, it voids the judgment.
But
It voids any judgments at any time obtained to the extent such judgment is determination of personal liability. And the underlying judgments here clearly are judgments pertaining to personal liability, are they not?
To the extent of personal liability, but we already have it in rem. It's an in rem, so it's not saying it's almost like a bifurcated thing. Well, if you have something that attaches to it, then it's fine. Anything over and above that is not.
If we were to say, and I'm not suggesting that this is going to happen, but if we were to say that Mr. Baker could go back under Rule 60 and seek to have the judgments, the underlying judgments, vacated as a matter of state law, would that be in conflict with the federal bankruptcy law?
I think it would be in conflict.
How?
Because it's giving more. It's not even looking at that's basically saying to a bankruptcy debtor, you can file a bankruptcy, and you can. The scheme of that says that you have a right to certain exemptions, and then that's basically like giving everybody a carte blanche of exemptions all around. you're not entitled to that. You're entitled to, here's the protections that you're getting under the bankruptcy code. You get to select, you get to keep property subject to certain exemptions, and then you get a fresh start. It's not to say you can keep everything and it doesn't matter, and if that was what was intended, it would have provided for that in the bankruptcy code, and it didn't.
But once the bankruptcy is over, I mean, this is where the state versus federal comes into play. I mean, once the bankruptcy is over, the bankruptcy code doesn't have an interest in what happens under a state law.
They don't have an interest, because it's the trustee in bankruptcy is basically administering the estate for the benefit of unsecured creditors. And if there was an exemption, if there was money there to be distributed amongst these folks, then they could do that.
All right, thank you.
Thank you.